Good afternoon, everyone. My name is David Lepofsky. By day, I am counsel with the Ministry of the Attorney General for the Province of Ontario, Crown Law Office Criminal, though I'm taking part in this webinar in my personal capacity. In my spare time, I advocate in a volunteer capacity on issues relating to accessibility for people with different kinds of disabilities. I'm chair of the Accessibility for Ontarians with Disabilities Act Alliance. If you're a Twitter junkie, at David Lepofsky. Welcome to the fourth in a series of webinars that the Law Society of Upper Canada has generously organized, sponsored, and deployed for your benefit, for the benefits of lawyers and paralegals across Ontario. The aim of these webinars has been to equip you as a lawyer or a paralegal to help ensure that people with a physical or mental or sensory or intellectual or learning disability, any kind of disability, can fully participate in court proceedings in Ontario, whether as a witness, as a party, as a spectator, as a juror, prospective juror, in any capacity, indeed as a lawyer or court staff as well. The first three webinars are available to you. They are archived. They are all accredited for CPD professionalism and hours, and having been centrally involved in organizing them, I can objectively say they're pretty good, and they're worth watching. This is the fourth in this series, but you don't have to watch the other three to pick up on this one, or you can watch them in any order you wish. This is going to run 2 hours, and it too is accredited for professionalism hours. Our aim today will be to focus on the specific needs of three different groups of people with disabilities. First, people with a physical or mobility disability. Second, people with a learning disability. And third, people with a communication disability. So why are we doing this? Well, for the benefit of those of you who haven't watched any or all of the earlier webinars, I'll summarize it like this. Over 18% of the population of Ontario now has a disability. That's over 1.8 million people, and that number is growing as our population ages. They face barriers everywhere they go. Some of them are physical barriers, some are bureaucratic barriers, some are communication barriers, some are technological barriers. They impede full participation in our society. Our courts are no exception. Our former Chief Justice, Roy McMurtry, announced back in 2005 that it was great that at the time the Ontario government was planning to enact a law, now on the books for 10 years, the Accessibility for Ontarians with Disabilities Act, aim at making our province fully accessible within 20 years to all people with all kinds of disabilities. Chief Justice McMurtry said the courts have to do their part too. He appointed a joint committee of the bench, bar, and government under the leadership of Court of Appeal Justice Karen Weiler to develop an action plan to make our courts fully accessible. I had the privilege of serving on that committee. 2007, the Weiler report was released. It's available in the webinar materials for this program and on the Court of Appeal website. It identifies the many barriers that people with disabilities still face in our courts and provides a workable action plan to lead to a vision it maps out of a fully accessible court system. So as part of the strategy for implementing the Weiler report, there is a permanent body called the Ontario Courts Accessibility Committee under the joint chairs from the Court of Appeal, Justice Janet Simmons at the present time, from the Ontario government, Assistant Deputy Attorney General for Court Services, Lynn Wagner. And this joint committee of the bench and the bar oversees the implementation of the Weiler report. We are making progress, not as much as we disability advocates would like, but a heck of a lot more than would have been the case had this enterprise not been undertaken. One of the things that we've tried to focus on is activities that lawyers and paralegals can undertake if they're involved in court proceedings to help tackle these barriers. I know that paralegals and lawyers don't build the buildings or operate the courts, but you are the person who is often the key in a key position to assist a witness or a party to overcome these barriers. In our various webinars, we've taken a closer look at many different kinds of disabilities Today, we've picked the three we're about to cover. Let me offer a couple of very quick observations, and we're going to jump right into our first panel. The first is this. There are some themes that you're going to hear today, and these themes came up in all the three previous webinars. And they boil down to this. Number one, if you should be proactively trying to ascertain if you have a client or a witness, or indeed trying to motivate your opposing counsel to find out, or a paralegal, to find out if they have a party, a client or a witness who has a disability that may lead to barriers in the court system that need to be accommodated. These things don't just solve themselves, and you may be the one who's got to raise the issue with the courts to try to deal with it. Second point is, raise it as soon as possible. Don't figure this out on the eve of trial and waltz into court saying, oh, by the way, I've got someone who needs sign language or Braille documents or something, because the courts aren't going to be able to rally those kind of supports at the drop of a hat. The earlier you raise it with the court system, the more likely you're going to get an effective resolution. And third, there are in place in our courts, thanks to the Weiler Committee report, in every major court facility, someone who's supposed to be your point person. They're called a court accessibility coordinator. And they're the one you go to find out what accommodations might be arranged. They may steer you to the judge to help facilitate it, or they may be able to give you information, or they may put the wheels in motion themselves. They're key people, and available through the Ministry of the Attorney General website are links to find out who these coordinators are, or just walk in the door of the court, go to the court staff at the front desk and ask who the Disability Access Coordinator is. The other key thing, before we leap into our first panel, I want to offer you is this. Beyond the specific points we're going to cover in this series of webinars, I want to highlight for you that your law firm, whether you're public sector or private sector, has accessibility obligations. It has them under the Human Rights Code, and it has them under the Accessibility for Ontarians with Disabilities Act. You have them in two capacities. As an employer, you have a legal obligation to become a fully accessible and barrier-free workplace. And second, as a provider of legal services to the public, if you're private sector, you have a duty to provide barrier-free, accessible services to clients with disabilities. So the kind of measures we're talking about today will be helpful to you, but I also encourage you to look up online the obligations that your firm may have under the Disabilities Act by going to the Ontario government's website dealing with accessibility. They've got links, they've got resources, they've got tools, they've got a wizard to help you figure out what you got to do and when you got to do it by. With that background, I'd like to turn to our first panel. All three of our panels will be done in the form of Q&A with me asking the questions and our wonderful presenters giving you the answers. To my left, if our camera can pull back, is our first panel on physical disability and barriers to people with mobility limitations. Briefly introducing, because online you've got available to you bios on everybody. To my immediate left is Jill Sawchuk, who works in the accessibility leads unit at the Ministry of the Attorney General, working on helping address accessibility needs across our court system. In the center is Steve Christensen, who has been doing fabulous accessibility advocacy work for the March of Dimes for many years, and who deals both with government and with consumers with disabilities, not just in the court context, but across all of society's different avenues. And finally, to my furthest at the end is Harley Knott. Harley is a retired lawyer who worked for many years at the Department of Justice here in Toronto in the area. He's got a mobility disability, and he will have more to say from his own personal experience. As we're going, if you have any questions, there is a Q&A link, and in our last couple of minutes, we will scramble to figure out what people are asking and if we can answer them for you, so feel free to use it. So I'm going to first turn to Steve Christensen. You're not a lawyer, you don't work in the court specifically, but you do work with folks with physical disabilities. Can you give us a sense of what kind of numbers are we talking about in the province of Ontario? How many people have a significant physical disability that would affect their mobility?
In Ontario, we're dealing, David, with approximately 17%. If we look at the provincial population of 13.6 million, that's a lot of people The majority of this number has a physical disability or a mobility-related challenge. Always keep in mind that nationally we're seeing 8 in 10 people with the disability using a mobility device, whether it's a cane or a walker. So we're looking at about 2.2 million bare minimum alone.
And that's across Canada?
That's just in Ontario.
Oh, just in Ontario. Okay, and could you help me out? What kind of different mobility disabilities we're talking about, and what are the causes generally?
The most common issues reported are mobility, flexibility, and pain. And I break it down into 3 categories of disability. You have your visible, and the most common image of that is the wheelchair. The not so visible would include things like severe arthritis, chronic lung or heart condition, which isn't immediately obvious, but it can impact a person's ability to climb stairs, stand for extended periods of time, or move across a room. And the third is the aging factor. This is the percentage of people with physical disabilities who are increasing with age. Aging and disability are closely related.
So when we think about the population breakdown of people who have a mobility disability, what percentage of them would be older folks versus kids or teens?
Well, interestingly, you have your younger group that goes up to about 24 years of age, and you're seeing about 4.4% of the population living with a physical disability. You get into your middle age bracket from 25 up to about 60, and it's the provincial average at about 16-17%. It's when you hit the 60 and 65 plus category that it skyrockets to about 43%. And if we get back to the numbers provincially, you add the population of seniors with a physical disability who don't often self-identify as having a physical disability, and you're moving upwards of 2.5 to some estimates of 2.8 million people in Ontario alone. And that's roughly equivalent to the official population of the City of Toronto.
And if we're looking at them as, so most people who've got a physical mobility disability, it's acquired during their lifetime, they're not born with it.
Some people are born with it, yes. You can be born with a disability and have a lifelong condition, for example, cerebral palsy, using a motorized wheelchair, and you will age with that disability. You will have people who age into a disability. The older we get, we might acquire severe arthritis, for example. And the third category there is the increasing category, which is resulting from an accident or a trauma or a stroke, which leads to acquired brain injury.
Okay, and urban versus rural, to what extent are these folks evenly spread between the rural community or big cities, or do people have a tendency, if you've got a mobility disability, to try to move to the cities?
Well, interestingly, physical disability is very non-discriminatory, so you're going to find every village, town, and city, and family for that matter, with physical disability present and personally close. But definitely the urban centers, and particularly the City of Toronto, you're getting a high level of gravitation because of the types and the numbers of services and amenities available that help increase a person's independence.
Okay, I want to talk to you, ask you just briefly about the visibility. I mean, I'm blind, I got a white cane. If I walk into a lawyer's office and they're sighted, they know I'm blind immediately. Somebody comes in with a wheelchair, they know they got a walker or a cane, they know they got a mobility disability. Somebody comes in and they're walking with no mobility device, should we always assume they have no mobility disability?
That's an interesting point, because physical disability is not always symbolized by the mobility aid. A chronic lung condition, as I mentioned earlier, is not necessarily immediately visible, but can be equally restricting in mobility.
And just for folks watching this webinar, for example, you might see somebody get out of a car parking in a disability spot. They've got a disability permit on their car, but they're not using a mobility device. You might wonder, are they faking or are they cheating? And some people do cheat and shouldn't be parking there because they don't have a disability, but some may have a limitation where they have a mobility limitation. They can walk, but they can only walk a very limited distance, and it is for that reason that they'll qualify for that. So the other sort of question to understand the kind of background about these disabilities, Stephen, is if I'm blind when I get up in the morning, I'm going to be blind in the afternoon, and when I go to bed tonight, I'll be just as blind. Somebody with a mobility disability, is it always the same all day?
That's where you get into some of the more complicated features of physical disability. Many can be episodic in nature. The challenges imposed can fluctuate, alternating between minimal challenges to severe restrictions. It can be in a day, it can be in a week, and multiple sclerosis, for example, acts this way.
Can you tell me what attendant care is, please, and who uses it?
Attendant care is a personal support service for people with physical disabilities or mobility issues that includes personal grooming. It can include washroom activity, getting to and from a medical appointment, an event such as today, or going to a courthouse, assistance at a restaurant, note-taking, turning pages. It's really helping that individual enable.
And if somebody has a physical disability and they need attendant care to go somewhere, where do they usually arrange it from, and who pays?
Well, March of Dimes Canada is one of the country's largest providers of attendant care. We're not the only one. There are private providers. There are others in the nonprofit sector, and that's provided through us.
And talk just briefly about stereotypes that face people with a mobility disability. We know that there are stereotypes facing all different kinds of disabilities. What are a couple of the common ones that folks with a mobility disability will face?
Some of the common ones, surprisingly and sadly, with the individual with a physical disability, there's an assumption quite often that the individual will also have a lower mental capacity or a developmental disability. Sometimes people will assume the person with a physical disability can't lead a productive life, for example, serving as a prominent lawyer or studying as a university student. That people are confined to wheelchairs, which is in fact not the case at all. That somebody in a wheelchair always needs help. And like anyone else, if you feel that individual requires assistance, you just ask.
And is there if you want to know if you've got a client or a witness who's got a mobility disability, is there a helpful way to ask them?
I would give the advice to the audience to remember that you are the enabler in this process, trying to achieve the greatest effective participation of that individual in the system. So you want to focus more on that person's abilities and less on the disability. You can always ask, for example, are there any accessibility considerations that I should keep in mind?
Exactly. For example, for lawyers who may, or paralegals, they might just want to put on their checklist when they're dealing with clients or witnesses, do you have any accessibility needs generally? And you could say specifically, if you want to put it on the list, do you have any needs relative to parking or getting in or whatever it may be or getting around? Okay, that's really helpful, Stephen. And I'm going to now turn to Harley Knott. Harley, you practice law. You now have the good fortune to be retired. So I'm going to cast your mind back to the days when you were slogging away at the Department of Justice. Can you tell us briefly what your disability is and what your law practice was?
Right. I have a spinal cord injury, so it's an acquired disability. I wasn't born with it. I dove into a river when I was 18, and I broke my neck, and it severed my spinal cord. Excuse me. So following that, I went back to school, got an education, went to law school, and wound up in Toronto as a litigator and in later years a prosecutor. I use a wheelchair for mobility, and I have all four limbs affected. I have quadriplegia, so I push myself, but my arms are half paralyzed and my hands are paralyzed also, which might not be immediately obvious if you see me pushing down the road.
Okay, and what courts did you practice in?
I was, as I said, I was a trial lawyer, a litigator, and then a prosecutor, so I've hit most of the courthouses in downtown Toronto. I've practiced in the federal court and federal court of appeal, here at 361 University, attached to Osgoode Hall, Old City Hall, doing prosecutions, up to Brampton quite often in the old courthouse and the new one. The old one was like a bus station, and the new one, I think, the Attorney General at the time, Jim Flaherty, described as a Taj Mahal, so there is a big difference in accessibility between them. And the odd time I would go to Oshawa or Hamilton.
All right. Now, the folks watching our webinar today, many of them are people without a mobility disability, and they're used to just going to court, parking, going in, going to a courtroom, and working. I want to now let them learn about what you experienced going to court. And let's first start with parking. What
Right.
kind of impediment barriers might you face in just finding a place to park?
Well, for instance, Old City Hall, there is nowhere to park. If you've ever tried to drive downtown and park by Old City Hall to nip into the courthouse, you're in for a shock. So I would often wind up parking a couple blocks away in a no parking zone or something like that and having to wheel there. Eventually, I was able to advocate for myself, and my office advocated on my behalf, and I got some parking access inside the courtyard of Old City Hall. But that would require going through the sally ports and identifying myself to the guards, and then dealing with staff to decide where I was going to park that day.
Now, when you talk about just wheeling from the place you park over to the courthouse and going in, people watching are probably just assuming that's a clear path. Did you encounter barriers getting from where you parked to getting into the court to getting to the grounds of the courthouse?
On a nice summer day, it would be a fairly good workout. On a snowy winter day or a rainy autumn day, it would be rather hellish. I would usually have a lap full of litigation cases, or a litigation case and a briefcase, quite a heavy load, so it was very difficult at times.
And once you get to the courthouse itself, what about getting in the door? Should we just assume every courthouse has an easily accessible door that you can just go right in, not a problem, with no stairs?
I think it's getting better, but when I was practicing, for instance, Old City Hall has some beautiful steps up to the front, so that rules out the front door for me. I was required to go in a back door, but it's got a fairly steep little ramp up to it and no sort of level porch area. And I believe it did not have an electric door opener at that time, so I seem to recall having to wheel up, balance myself on an angle, push a buzzer because the door was locked and guarded, and hope that a guard was on duty right at the door. Sometimes they weren't, and the intercom would need to locate some administrative staff who would then have to locate a guard who would then have to come and open the door.
And this is before when your mind's on preparing for court.
Yes, that's right. Right here in this building, I had...
You're in the Osgood Hall building.
Right now in Osgood Hall, yeah. I had an appeal once at the Court of Appeal, a criminal appeal, and I only found out, as you know, the courtrooms aren't always decided, sometimes until the day of the appeal. So I came in to find out that the courtroom I was assigned to had no access to it, no elevators, nothing but stairs. I made a request that the appeal be moved to an accessible courtroom. That was refused by the panel of judges, and they insisted that I be carried down some stairs by a couple of guards. And so that was an undignified and kind of worrying experience. The guards weren't in the best of shape. One of them split his pants on the way down, and my mind was completely off the appeal and on access issues.
And being carried up or down a flight of stairs, aside from an issue of personal dignity, what about your personal safety?
Well, as I said, the guards were huffing and puffing, and I didn't feel entirely safe the whole time.
Let's get past, so in some courts, you can get in the front door without assistance, and some you need help because they may not be fully accessible. Then when you get in the building, if there is an elevator, can we assume that it's always got buttons where you can push them?
Not always, no. It seems to often depend on the age of the building. In the older buildings, the elevator buttons tended to be up high and often just out of my reach, so I'd have to hope there'd be somebody else in the elevator who I could ask to push a button. In the newer buildings, like the new court in Brampton, or what was the new court then, everything was quite accessible inside, but the parking lot seemed to be miles away from the building, especially on a winter day again, and I remember having a lot of difficulty getting to the building itself.
Now, you've told us that some buildings will have an accessible courtroom, some rooms will be accessible and some won't. Talk to us about what happens when you get into a courtroom, assuming there's level access to get in the door. For one thing, do they sometimes have those heavy doors?
Well, most courtrooms have a set of double swinging doors. I always found it was okay going one way. I could push my way through, sort of barge my way through, and the doors would open. But coming back the other way, if they didn't swing both ways, then I would have to be, again, with a lap full of a litigation case and a briefcase, trying to lean over forward and pull a door into the space my wheelchair was occupying with one hand, one paralyzed hand, and try to push myself through into the space with the other hand. And then once I got in the middle, I would often get stuck because there's no room to maneuver in between the two sets of doors. So again, I would have to hope that people were coming and going and that could hold the door for me. And it always, or not always, but it often made a bit of a scene. And that's one of the things that bothered me most, is that I could not just coolly breeze into a courtroom, set myself up, and get to what I was there to do. I had to fuss with the logistics and details and be asking people for favors and for help. And some of that is unavoidable. Some of it, though, a lot of it could have been addressed by some very simple access measures.
Second last thing I want to talk to you about is the desk. You get in the courtroom, you've gotten through all of these other issues. The counsel table where you're going to work, always one that you could work at, sometimes not. What was it like?
No, usually the counsel table was an issue. They often had a wood curtain that came down below the level of the actual table. So
at the front towards your lap.
At the front, right, and my knees would bang into that. So I would need to kind of reach and lift my heavy cases onto the table without being under it. And then I'd have to pick my legs up and off the footrest of my wheelchair and drop them down to the floor as low as I could and try to squeeze myself under the table. And then if I needed to move quickly out from under the table to address a witness or address a jury, for instance, that was a problem. It was awkward, and my legs were swinging around and dragging on the floor, or I was fussing around picking them up and putting them back on the footrest. And all of this gets in the way of examinations and argument.
If you need to approach the witness with a document, always a clear path?
Not always. A lot of the courtrooms are pretty crowded. Sometimes there's a clear path, but often the witness box was raised, and I can't grip with my hands, so I could sort of hold on to a piece of paper and pass it up, but there were a few times when it would just slip out while the witness was leaning over trying to grab it, and then again, it was a bit awkward.
Finally, at the risk of being a little indelicate, the court gives you a break mid-morning. We're all used to it. We all think about the same thing, which is, where's the bathroom? Your situation.
Right, so when the judge says we'll resume in 10 minutes or 5 minutes, I have to pray that there's a bathroom on the same floor. If not, like Old City Hall and 361 and a lot of other older courthouses, there might be one or two accessible washrooms for the whole building. So I would be dashing madly in the break, going through various floors and hallways, through heavy doors, trying to get to the right elevator, to get to the right floor, to get to a washroom that often didn't have a door that was easy to open, to get to the one washroom that had a wide stall in it, and then do what I had to do and try to get back to court within the allotted time. I was often late back to court from a bathroom break. And to be fair, most of the judges, I think, were quite understanding about that, but not all of them. And I think it's something that could be addressed with judges' training that perhaps didn't exist then, hopefully is more of a norm now.
All right, thank you very much. I'm going to finally, for this panel, turn to Jill Sawchuk. Jill works with an excellent team of folks at the Ministry of the Attorney General who are working on taking this on as problems, ways to make our courts more accessible. So, Jill, let me ask you just some practical questions, because people watching are wondering, okay, what do I do about it and who do I call? So the first question is, we've heard these anecdotal reports from Harley. Can you tell me generally how how accessible or not accessible are our courts across Ontario? I'm not looking for stats, but just generally.
Yeah, I mean, we have over 160 court locations administered by the province, and are they all accessible now? No, the majority of them are not up to today's standards. Many of the courthouses were built before accessibility was considered, and even when you look at how we might have built for accessibility or how we did build for accessibility in the 80s and 90s, so some accessibility features is very different than how we do things today. So what you'll find is in the newer courthouses, in the past 5 or 6 years, for example, we've built some consolidated courthouses that brought a number of different court locations together in different communities. And so you're going to see a lot more advanced accessibility features in those court locations that you're not going to see in our older facilities.
And what's the ministry doing now to address the majority of courts, which are old buildings?
So, we know we have a ways to go in this area. So when we renovate, of course, every year we're renovating and making upgrades to courthouses, we incorporate accessibility as much as we can in those renovations. But we're also planning for priority improvements over the next 9 to 10 years for all of our existing courthouses, including the older court locations, and with a focus on making those facilities accessible.
All right, so our audience is watching, and let's say that we've persuaded them through this program that they better ask their clients and their witnesses much earlier about possible accessibility needs. Who should they call?
Well, you mentioned them, we have our courthouse accessibility coordinators in place for all of our court locations, and I just want to briefly explain their role is that they are available to respond to all types of accessibility questions from any court user with a disability. So whether if it's somebody who's represented or a self-represented person, a juror, etc. And their role is very important. We implemented this beginning in 2009 because not all disability-related requests are common. What might work for one person may not work for another person. It depends on the court location. It depends why they're at court. So it's a very individualized process. So keep that in mind. But nevertheless, there are some common accessibility requests that we do get that are responding to the needs of people with physical disabilities.
So what kind of things could people ask for or can be done?
Okay, well, there's a range of things, but there's a lot of requests that we get for general assistance for people who just need some help getting in and around the courthouse.
Someone to guide them?
Guide them, help them navigate the courthouses. If there are no accessible door openers, then there are people there to assist. While not great for independence, that support is available.
And
also,
they're not just standing around waiting. You've got to pre-request this so that they're available.
You do have to pre-request that, but generally if you were to ask a staff member for assistance, they would assist or go get somebody who could be available. But the other thing too is where it does require some advanced planning is that if, for example, the front entrance isn't accessible or as accessible as needed for an individual, then there may need to be arrangements to escort people through the most accessible path of travel and get them to where they need to go. So that's one example. We've just implemented wheelchairs in all of our court locations. So
you mean the ministry owns them and has them available for someone?
Yeah, they're available, just implemented in the last couple of months actually, and so these are on hand if anybody has any mobility issues. So not people who bring with or have their own wheelchair, but sometimes we find for people with stamina issues or other disabilities that don't necessarily warrant having their own device, these are available to have on hand. People, because sometimes spending a long day at a courthouse or making their way from the parking lot around the courthouse can be a challenge. So there's that. So we're happy to have those on hand. Scheduling. So this is something that we do get a lot of requests for and respond to. So sometimes traveling to the courthouse can be a challenge. We do respond to requests for teleconference and video conferences if that is appropriate.
I mean, instead of having to come to the courthouse physically.
Correct, instead of coming in person, and that's available for anybody in some cases, but for people with disabilities, this can be of great value. Once you're in a courthouse, we will often have some spaces within the courthouse that are more accessible than other spaces, so arrangements can be made to schedule a court proceeding in a particular court room that has more accessibility features to
So
meet
counsel or a
particular's need.
paralegal should be calling the court access coordinator as early as possible.
Absolutely. Anything in relation to scheduling, where the courtroom is, if you need a courtroom that's maybe closer to the accessible washroom, these are all things that those arrangements can be made, but you're right. Some advanced planning is needed. That's not always the kind of thing that you can do on the fly.
And just as a recommendation to lawyers and paralegals watching this, it is especially valuable if you've got clients or witnesses who have these needs to get them to come to court a day or two before to scope out the location, because just because you're told something is accessible doesn't mean it is, or somebody may have put, I love these, a sign in the way. I usually find them the hard way, or something like that. So it's best, and to find the bathroom and whatever, best to have them scope it out. And again, if they want to come a day in advance, can they call and book for someone to meet them to assist them?
Absolutely, and we would encourage that, to think through those sorts of things that your client might encounter. Tell them how the day is going to go, how the week is going to go, what the expectations are going to be on them, so that together you can think about what their needs may be and then connect with the accessibility coordinator in advance, can come to the courthouse and walk through issues, make arrangements that may be needed for a drop-off if the parking lot is farther away, an escort through the building if needed, court locations that are accessible. The other thing we have made arrangements for is special equipment that somebody may need. So we've had requests for special chairs be brought in. Sometimes we rent them. Some people sometimes bring their own because they're so customized. But supportive chairs that aren't wheelchairs but are something in between an ergonomic chair and a medical chair.
Something that's more comfortable than that wonderful ministry furniture we have in some courtrooms. Gotcha.
That's right.
Does the ministry ever provide attendant care if requested?
The ministry does consider that. Again, it's a very personal issue, so we first would say, do you have somebody that you use that you would bring? But we know sometimes that there are limits in terms of what people have access to. So yes, we would consider that request, and we would provide it. We've had requests for potential jurors, for example, where we've arranged for and paid for that type of support.
And again, you don't walk into the courtroom on the day and say, hey, we need attendant care. You got to let people know about this way in advance so that the ministry can look into it. And just so you know, the court access coordinators, each location, are trained up and working with these, but they also have access to Jill and her team at head office if more unusual or complicated requests come in. Let me just turn finally to we have people watching who are members of law associations or may just personally have gone to their courthouse in their community and said, this is not accessible enough. What can we do about it? If they want to raise this with the ministry to try to get action speeded up on retrofitting their courthouse in their community, who should they contact?
Okay, I just want to say two things with respect to that. One is if there is an immediate pressing need for one of your clients, your fastest way to have that dealt with is through the accessibility coordinator. But if your comments are more general, as you said, somebody wants to share their experiences, share their concerns more generally about the accessibility of a courthouse in their community, then you can send a letter or an email to the ministry's head office, and the feedback received this way gets routed to the appropriate department for
There is a feedback page for feedback on accessibility issues, and that gets routed through the right department in the or office within the ministry to deal with it?
Correct, and that information is in the materials that I shared, all the contact information about the feedback process and the accessibility coordinators.
Now, the other thing I will say in my capacity as a private individual is that if you or your law association want to ramp up the pressure for getting ramps in your local courthouse or other changes, or even just get the furniture more accessible or automatic door openers, it never hurts to write the Attorney General of the province. It never hurts to contact your member of the legislature. Those kinds of good old advocacy efforts in a democracy can help move your project further up. Most people out there think that, well, they're fixing them whenever they can or whatever, but frankly, that kind of grassroots advocacy from a law organization can really help ramp up action in this area. I choose my terms advisedly. I want to thank my first panel, invite them to go to the cheap seats, while I invite up our second panel, who will be coming to my right side and will be talking to us about learning disabilities. as they're coming up and in their seats. I'm just going to do a quick introduction here. We have now gone from talking about a disability that is involves very physical, practical requirements like a ramp or buttons they can reach in an elevator, or to get into a room, or furniture adjustments, or frankly just more time to be able to get to the bathroom. I want to talk about stuff that may seem a little more amorphous, and it's equally important, and it's in the area of learning disabilities. There are lots and lots of people in our society who have learning disabilities. I'm going to gamble many of you have met people with learning disabilities who thought they might have one, but you might not know a whole lot about it unless you have a family member or yourself you have one. So assisting us are two experts in the area of learning disabilities. Beside me is Stacy Brooks, and beside her is Mitchell Kersey. Mitchell works for the Learning Disability Association of Toronto, and up until just a few days ago, so did Stacy. And they've both done excellent work, both in learning about the needs of people with learning disabilities and advocating for them. So I'm going to be throwing some questions at the two of them, and they can take their free jump, whoever wants. And we're going to be assuming that the people listening to us don't know much about this. So could one of you or both of you take a shot at telling us what the heck a learning disability is?
Okay. A learning disability refers to a variety of disorders that affects learning. Especially in the area of the acquisition of language or information, what we call input. It affects the the retention of that information, how long we hold on to that information. It also impacts how we understand and how we organize the information, what we call integration, for the purposes of processing and then retrieval. Which leads then to the use of that information in a verbal or nonverbal text in terms of output, what we call expressive language.
So it's either a challenge in getting the information in or a challenge in getting the information out. Talk to me. I may go off the schedule, the sequence I told you we were going to when we're talking, but that's good to keep you on your toes. Are we talking about people who have an intellectual disability?
No, an intellectual disability is different than a learning disability. An intellectual disability is where someone has a severe impairment in learning, whereas a learning disability, a great area to remember with a learning disability is, including in their diagnosis, they have to have average to above average IQ.
So people with a learning disability are, by definition, they have an average or above average IQ. One way I've heard a learning disability defined is as a person whose intelligence or IQ rating is significantly higher than they perform on certain standardized academic testing, like reading, writing, or math. So their academic scores on those kind of measures are markedly lower than their actual intelligence as it is assessed. Can you give me a sense of some kinds of learning what are the different kind of categories or some of the different ones that are out there?
Some of the subsets of learning disabilities are what we call dyslexia, which is a language-based learning disability which affects reading and related activities such as reading fluency, reading comprehension, and writing. Dyscalculia, which affects the person's ability to understand math and basic math facts. Auditory processing disorder, what we sometimes refer to as central auditory processing disorder, and that's about how the sound travels, through the ear, is processed and interpreted by the brain. Then there's nonverbal learning disabilities, and that's how nonverbal learning disability interferes with nonverbal communication, the understanding of nonverbal cues, facial expressions, body language. And then visual perception, visual motor deficits, which impact our understanding of information that's presented in a visual format.
And how many people have a learning disability?
Currently, it's estimated that approximately 10% of the Canadian population is living with a learning disability, and it's actually one of the fastest growing disabilities in Canada, not related to aging.
So not related to aging. So let's talk about that. Are you born with it, or do you get it during your life?
You are typically born with it. However, there are circumstances where someone might have a brain injury, and the impact on their brain because of that injury has them processing information as someone with a learning disability would.
Now, on the panel we just went through, we were talking about people with mobility disabilities, and some of them are fixed during the day, and some are better or worse one day after the next, or at different times of the day. Is a learning disability, and I drew the comparison of me, I'm as blind in the morning as I am at night. Are people with learning disability, is it the same morning, noon, and night, day after day, throughout their life?
So a learning disability is with them for their entire life. And again, if it's with the brain injury, since that injury, it would be continuing forward from that point on. And their areas of struggle will depend on where their learning disability lies out of the list that Mitchell mentioned there. And what it is they're trying to deal with throughout the day will impact them differently.
Okay, so
And if I could
go ahead, sure, jump in.
if I could add to that, is that just touching upon what Stacy just said, that learning disability is a lifelong condition that evolves over time. So to give you an example, let's take an underlying language disorder. In a preschooler, that disorder might look like a delayed speech. The acquisition of early speech. For the elementary student, we would see that as a reading disorder. As a student moves up, say into high school, we'd see that develop into a writing disorder. And later on in the adult stage, we might see that emerge as functional literacy, the inability to deal with reading forms, pamphlets, books.
Okay, so in other words, it can look differently, it can manifest itself differently during the lifetime, even though it's the same condition.
Mm-hmm. Yeah.
And is two people with the exact same diagnosis function exactly the same or differently?
They will function differently. Also, they don't have to have only one diagnosis. An individual with a learning disability could be affected by a variety of the lists that Mitchell went through previously. And even if they're diagnosed with the exact same learning disability, the way in which they get support and overcome any challenges they're facing from it could be completely different.
All right, so this is really helpful. What about it occurring in multiple disabilities? Do you see it overlapping with other conditions?
Yeah, we see that as what they call learning disability and comorbid disorders. And what we mean by comorbid is that these are conditions that have distinctive symptoms, but they occur with the learning disability.
They're more often to show up. They don't necessarily show up, but they're more often to show up.
Show up with the learning disability. So,
Right.
Some comorbid disorders would be like attention deficit hyperactivity disorder, conduct disorder, social disorders, obsessive oppositional defiance
right.
disorder.
Okay, thank you. And if how many we talked about how many people have a learning disability. I'm interested to know how many people who come through our court system we know to have a learning disability, at least the criminal justice system.
Yeah, so there's a few statistics on the American and a couple on the Canadian. For the juvenile system in the States, approximately 55% of individuals with learning disabilities within 8 years of graduating finishing high school, leaving high school, I should say, not necessarily graduating, but within 8 years of leaving high school, they have had conflict with the law. Approximately in the 40% range of individuals in the prison system in the U.S. have stated that they do have a learning disability, and it's upwards to 25% of individuals in the federal system in Canada that have a learning disability.
And people with learning disabilities, is it typical that they would self-describe, or themselves as having a learning disability, or what might they say?
So it really depends. Again, the statistics in Canada are a little bit harder to know how many have self-disclosed because of privacy acts, but about 4.6 million Americans have stated they are living with a learning disability, adults, and of that, 19% of them have disclosed in the workplace.
Okay.
Here, we also see a lot of the time adults might not have an official diagnosis, but are self-disclosing that they feel they're living with a learning disability.
Oh, interesting. What kind of stereotypes do they face?
Well, going back to the self-disclosure, a lot of times adults are very reluctant to self-disclose because of the stigma attached with that learning disability, and how they perceive themselves. Individuals with learning disabilities have feel a lack of self-worth, low self-esteem, poor self-concept. That, for a lot of individuals with learning disabilities, they're risk adverse to opportunities. They will shy away from opportunities for success. And on the other end, a lot of times individuals with learning disabilities will be prone to harmful behaviors and poor choices. They bring with them, some feelings that they are incapable of success, that they are dumb, they are losers. A lot suffer from what's called the imposter syndrome, that if they do achieve, they feel guilty about that achievement because of the accommodations that they've received, that they don't realize that the accommodations are there to level the playing field, and they will look at those accommodations as, as a leg up on someone else.
Who diagnoses a learning disability?
Learning disabilities can be diagnosed by a psychologist or by a medical doctor.
Okay, and psychologists are often the place where you go for this because of the testing that they do, that it can focus specifically on this. Talk to me now. Let's shift from what the condition is, and before we go to court, let's just talk about some of the adaptive technology and strategies that are available for people with learning disabilities. And adaptive technology for people with all kinds of disabilities is changing at a unbelievable rate of new things coming out constantly. But can you give me just a few examples of the kind of things that are available to assist people with learning disabilities to fully participate?
Yeah, David, some of the ones that we see most often are voice-to-text softwares, text-to-voice softwares.
Okay, let me just, for lay people out there, voice-to-text is like Siri, where you talk to or Dragon Naturally Speaking, you dictate, it types. And text-to-voice, which is what we blind folks use, is when you call text up on the screen and the computer reads it out loud to you.
Yeah, we also have word recognition. So while they're typing, the software actually can help recognize what words it is they're attempting to put on the paper, as well as spelling and grammar checking. And organizational tools are a really big thing with individuals with learning disabilities as well, help keeping them organized, calendars, timers, agendas, things along those lines, both technological and hard copy paper ones.
Let's turn our attention to courts. We've now got a sense of what the spectrum of people with learning disabilities might face. First things first, I'm a lawyer, I'm a paralegal, I've got a client or a witness in my office. How do I know if they have a learning disability? Are they going to tell me, or do I just say, hi, do you have a learning disability? Or what do I look for, and how do I ask?
Yeah, so not necessarily. They won't necessarily tell you, especially if it's an individual who's maybe uncomfortable with disclosing or unsure themselves. Really being in a comfortable setting is a great start for anyone to want to disclose something about themselves like that. But things that they might want to look out for are, as we mentioned, the biggest thing is processing input and output. So taking longer to take in the information that's being given to them and taking longer to get out information back to the individual speaking with them.
If you are working with a client or witness and you observe that should be a clue for you.
That could definitely be a clue or a sign to start looking for maybe some other signs as well. Or even asking if there's any way that you can help them to understand the process better and see if you can get them to start to disclose things that would help accommodate them.
As a general theme in these webinars, and for those of you who haven't watched the other ones, even though I've been plugging it obnoxiously throughout this entire process, one of our themes is that instead of sitting down with someone and giving them a checklist, do you have the following disabilities, being able to list for individuals, whether it's a client or a witness, a series of functions and say, is there any way we can assist you with, you're going to be involved in a court proceeding, either getting to the court, getting in the court, getting around the court, that's the panel we did. If we're going to be asking you a lot of questions and expecting you to speak and answer to the court, Is there anything that we can do to assist you in doing that? Or if you're we may be presenting you with written materials or maps or documents. Is there something we can do to assist you so you'll be able to do that? Or do you have any difficulty with that you want to let me know about so that we can be sure to assist you? Those kinds of functional questions that list the activities that we all know are the core things that clients and witnesses have to do in court may be the most inclusive way of asking and unobtrusive way of asking.
Yes, just to echo that, David, the lawyer or the law firm, they want to demonstrate that they are disability friendly, that they've accommodated individuals with needs in the past, and that they're fully ready to do that, and that they could demonstrate that by giving them examples of where they've done that in the past with clients.
Okay, no, that's very helpful. So let's talk about the barriers that a person with a learning disability may face. And I realize you said some it's a question of visual processing of printed material, other it's audio processing of spoken information, but what kind of barriers can they face going and being a witness or a party in a court proceeding?
So the process in general is probably going to be a bit of a barrier. It's an unknown, unfamiliar situation, not knowing where they're supposed to stand or go or when to speak or when not to speak. So really walking through with them those steps to help them be comfortable and familiar with the actual court proceedings would be a huge benefit for an individual.
And of course, it's helpful for any client or witness as well.
Also, like you said, the language. If there's language, which there is, that is used typically in a court proceeding, to really have them understand what those words mean, the context behind them, prior to having them heard in the courtroom, so that they might already take a little bit longer to process, but they understand the language that's being used around them.
Yeah, and to touch upon that, I think it's very important to help the individual to anticipate what's ahead for them, so that there are no surprises. So, like I said, anticipating the questions that they're going to be asked, helping them to formulate the responses to those questions. Rehearsal is very helpful for an individual with a learning disability, because we want to kind of like tamp down that anxiety that they're going to experience, in a court proceeding.
Now, our folks watching this webinar will nod their head but say, I do that with all witnesses, or I should. So I'm going to drill down a little further with you into the specific needs of people with a learning disability. Not that what you're saying isn't helpful, but I want to get more specific. So let's break this down into parts of what goes on in court. In court, we ask witnesses questions. That's what we lawyers and paralegals will do. What kind of problems may a person who's a witness with learning disability face, and what can we do to make that process easier for them?
Right. Well, a person who has auditory issues, right? When hearing the question, they might not understand the question, so the question has to be explained to them. One of the ways in which you can support an individual with auditory issues is to provide with them adaptive software, so that you have speech to text
So when you say audio, you mean it's not that they can't hear well, it's auditory processing.
It's auditory processing.
For those people, it may help them, the sound coming in their ears, they may have trouble processing and understanding, but if they had the same questions asked, printed out in front of them, you're saying they may be able to understand it better?
Absolutely.
So for them, real-time captioning, which in our second webinar we talked about for people with hearing loss, could be very helpful for them. What about the time the witness needs to take to answer the question?
I think that's extremely important as well, that individuals in the process are taught and understand that it might take longer, and it's not that they don't have the answer or they're trying to kill time because they're coming up with an untrue answer. It's that it just takes longer for them to process the information going on in their head and get it back out for the individuals to hear.
As you're talking, we know, those of us who work in courtrooms, the courtrooms are a pretty tense place, so they're pretty tiring for all of us. A day in court, you come home, you're tired. For somebody with one of these, especially auditory processing issues, how is it for them?
It could be very fatiguing for them. The fact that they have to listen so closely to, to what is being, said in court, and trying to understand that without the adaptive technology, it can be very tiring for them, and they'd need breaks.
Okay, so more frequent breaks for a witness, or if it's a party, if it's your client who's got to listen to everything so they can assist you, not just when they're testifying, more frequent breaks would be helpful for them as well. Talk to me, if you wouldn't mind, about documents. We use documents in court. We present witnesses with documents. We show them maps. We ask them to point things out on maps. We show them photographs, ask them to recognize people. What issues can this present for a witness, for example, who has a learning disability?
So I think it's also, just to chime in here, really important to understand that an individual with a learning disability will have an area of extreme strength as well as their learning disability. So being able to find out, or trying to find out, where that strength lies in your witness or client is super important as well, because you can tap into that strength to help them accommodate what might be their weaknesses. But with that being said, if it's someone who is having some struggles with reading a document, as Mitchell mentioned, there's software available that can help them. In this case, it would be text-to-speech might be something that would be beneficial, so that if reading and visual LD is the issue, then hearing it might be something that's easier for them to understand.
Let me just jump in on this, because I'm in the same boat as someone who's blind, and I work in courtrooms where we're using documents all the time. If somebody pops up and wants to quote something, I will ask for the court or the lawyer or the witness to read it out loud. So even though you're looking at somebody who's not got a white cane, doesn't appear to have any visual limitation, it's pretty much the same accommodation for them as it is for me.
It would definitely be an accommodation that would help them, yes.
And also, similar to the screen reading software that blind people use, there are similar products that the person with dyslexia may use, and they in turn may want to have that available in the courtroom. If a document is presented, if you give it to them electronically, they could have the computer reading it to them, and then they can answer the same way a blind witness would. What about maps and pointing out things on maps? We're talking about words. What about symbols?
Right. Someone with a visual spatial disability would have difficulty understanding charts, understanding maps, understanding graphs that might be presented. So in a situation like that, they would have to have that explained to them verbally.
And this is important for anyone practicing in the courts to know, because how many cases involve somebody presenting a chart or a map and saying, where were you, or do you recognize this person, and not even thinking whether they might be one of the 1 in 10 people in Ontario who've got a learning disability that may affect their processing of that information. I want to turn our attention to, just for a couple of minutes, to the issue of body language and demeanor. We all know in court that if it's a trial and it's a judge or a jury deciding on the credibility of a witness, they scrutinize the witness's demeanor as an indicator of their honesty. Their eye movement, their posture, and so on. Can learning disabilities lead a witness to engage in physical behavior that might be misread by a judge or a jury as signifying they're dishonest or they're not to be believed?
Definitely. A nonverbal learning disability is all about the nonverbal communication. So eye contact, body language, reading facial expressions, their own facial expressions, tone of voice, both reading and
I'm going to stop you.
Yeah.
Eye contact. What's the problem? What's their limitation with eye contact?
Some individuals with a learning disability might not be comfortable or able to make eye contact the same way someone without a learning disability would.
Okay, and when you said facial expressions?
Both using their own facial expressions to represent their emotions and reading others' facial expressions to represent what they're feeling can be a difficult task for some individuals with a learning disability.
That's correct. So an individual with eye contact, they might give minimal eye contact, right? They're going to shy away from that. And they might find that direct eye contact from someone else can be very distracting to them. And with facial expressions, they might stare inappropriately at times, and they might smile at inappropriate times, and that could be misinterpreted.
Okay, so now let's talk about what do we do about these barriers. The first thing is, if you've got a client or a witness who doesn't have a diagnosis, but you may think have a learning disability, the place to get advice or assistance would be to a psychologist. That would be your first stop.
I think, if you suspect that, a client has a learning disability, yes, you'd want to speak with a psychologist and talk to them about the behaviors, what you've observed with the psychologist. You would, if it's someone with, say, attention deficit to hyperactivity disorder, and you want to find out about, the behaviors that are common with that, you'd probably want to speak with a medical doctor or a psychiatrist.
And in the case of ADHD, that can affect, if they're on medication, different times a day could be better for them, and therefore that can affect when you want them testifying or not on the stand. What in the courtroom can a lawyer or paralegal do to assist with these issues you've mentioned about? You've already talked about more frequent breaks and about walking them through the process in advance. Are there other steps a lawyer or paralegal could do to try to assist the witness or the client with a learning disability so that they are able to fully participate?
Yeah, I think, like you mentioned, describing the court process in detail is a great start for every individual, and especially individuals with learning disabilities. Also, like we talked about, the language prior to going in, but also building that rapport is such a huge part so that when they're in the courtroom, their level of anxiety can be less because they do have someone that they've built that rapport with and they feel comfortable with in the courtroom. If they have a question or need to take a break, they have that individual there to rely on. I think that's a really huge part, is really feeling secure and safe in their surroundings once they're in the court process.
Yeah. So I think, touching upon that, by building the self-confidence of the client who's going to be in the courtroom, addressing the questions, you want to build the confidence and you want to empower them within the whole process, right? And if they accept that it's good to self-disclose and they're confident about doing that, then you could ask those questions in court of the client about what type of supports do you think you get them to describe what their issues are, get them to describe what their needs are.
So let me just thank you very much. I'm just going to wrap up this panel by just making a few of my own observations. I think there's a couple of things I'm going to suggest that leap from what we've just heard. I think the point about fatigue is really powerful. If we have to concentrate a lot in court, if people who are new to court, witnesses and parties who have something at stake have to concentrate even more, people with a learning disability may have to concentrate even more than that. And being tuned into that and to the fatigue it could associate and the need to accommodate that is huge. The ability of counsel or a paralegal to be alert to the possible clues that they should be watching out for, to be able to ask the client or witness whether they need extra time to understand questions or to answer questions, whether they need more frequent breaks or whatever, and taking steps along the way to make sure that they understand what you've asked them, they're not just parroting it back, and so on, are all huge steps. But I want to just take a couple of moments to conclude this particular topic with an important role that any litigator has in a courtroom, which is if you've got a client or a witness with a learning disability, as well as with other disabilities we've covered in this series, you have an important role to educate the judge or the jury about their disability if it's necessary to enable them to do a fair assessment of your client or witness's credibility. We've learned from from Stacy and from Mitchell that the individual may engage in behaviors that could be misread as leading to a doubtful credibility. And to that end, the question arises, how do you convey this to the court? And there are a couple of ways of doing it. If you need to, you might call a psychologist to testify about the nature of the learning disability and how it affects their understanding and processing of information and behaviors so that they can then make a fair assessment. They're not commenting on the credibility of a witness. They're not an oath-helping witness. They're just providing some context to be able to assess them. You may ask the individual, as you just heard, if they're comfortable with it, to self-describe. There are times that you may, and this is probably a little more challenging, and you may wonder whether this is whether you're comfortable doing this, but you may simply signal the court by saying, my client is going to testify that they have a learning disability. My understanding is it relates, can affect their ability to audio process questions. I am therefore going to go very slowly, and I'm going to ask them to answer very slowly and take all the time they need, which is also a way of signaling to the opposing counsel that if they try to race in, it may not be that well received. But that kind of educating of the court, and if you can, through a psychologist, if there's a way of describing those kind of behavioral mannerisms so that people don't misread the what might seem as an inappropriate smile or a eye movement or direction of gaze, that's really important. Of course, this is not all one size fits all. People with the same condition as you heard may present very differently, and so it's got to be tailored to the individual. I'm going to thank our panel. I'm going to ask you to each move over one seat, and I'm going to have our sole presenter on our third panel to come up, Pamela Cross, for our last presentation. And our camera person will be nice enough to keep Pam and me in the camera, and Stacy and Mitchell won't be in the camera in case they're rolling their eyes as we're presenting this at the content. Pam, hi. This is you're Pam Cross. You're a lawyer.
I am.
We're here to talk about people with communication disabilities. What do you do for a living, and why are you here talking about people with communication disabilities?
I'm a lawyer. I work on access to justice issues, primarily working with women who've experienced violence or abuse in their lives. But that work several years ago started to overlap with working with women with disabilities, including women with communication disabilities. And through that, I got involved with the work of CDAC, which is the the Communication Disabilities Access Canada organization, because this was a community that clearly was experiencing significant access to justice issues.
So what is a communication disability?
A communication disability is any kind of speech or language disability that is not the result of hearing loss.
So give me some examples.
It can come at either end, and here we overlap a bit with what we've heard from our earlier panelists talking about learning disabilities, for sure. Somebody with a communication disability may have difficulty on the speech side. In other words, they may not have the vocabulary, or they may not be able to speak in a way that's clear enough for other people to
So we're talking about
understand.
cerebral palsy, for example.
We could be multiple sclerosis.
Stroke survivor.
That's right. Or it could be at the receiving end. So it could be the individual's ability or inability to communicate, but also their difficulty in understanding what is being said to them.
And what kind of numbers are we talking about in our society have communication disabilities?
About 1.3% of the population has a communication disability. In Ontario, that's about 165,000 people.
And on the age, do we know about an age distribution? Are people usually born with these? Give me a bit of a demography if you can.
What I can tell you is that this can be something that is with the person for their entire life. It can also be triggered by an acquired issue like an injury or an illness. And certainly as the population ages, as I think we've heard from everybody else here today, some of these issues can become more extreme.
Now, we just going through the spectrum of our panels that we're covering today, everybody had heard about mobility disabilities, and everybody's seen somebody in a wheelchair using a walker. We've all heard about learning disabilities, but probably didn't know as much before this panel as we do now, the last panel. But you're on kind of newfangled turf.
I think that people with communication disabilities are often a little bit hidden, sometimes in the shadow of people who have hearing loss. Most of us understand hearing loss. We understand the need for interpretation, accommodation, and other supports. But people with communication disabilities are often quite hidden, partly because of the very nature of the disability. These are people who cannot communicate effectively. And so often they are literally silent. We don't know that they're there.
And what we heard earlier about adaptive technology, some very cool new stuff available for people with learning disabilities. What's happening on the adaptive technology front for people with a communication disability?
Lots. I think many people who are watching this webinar would be familiar with something like, for instance, the Bliss board, which has been around since I was a kid, so it's been around for quite a while. Very helpful to somebody who has a communication disability. But we've moved on considerably because of advances in technology, so that people can have laptop computers, tablets, letter boards and picture boards that are custom designed for them. So the board that works for you, for instance, if you have a particular kind of communication disability, would not be the board that would work for me because I have a different kind of communication disability. So technology is definitely our friend here when we're talking about communication disabilities.
And do we know, I mean, people in wheelchairs who can't walk, we've kind of known about that for like a long time. I mean, professionals have, and we've got newer wheelchairs than before. But is our knowledge about communication disabilities growing as quickly as our adaptive tech is growing, or?
I think that that's fair to say. Now, of course, I'm commenting from the perspective of being a lawyer. I'm not a speech-language pathologist. I'm not an expert on the details of different kinds of disabilities. But certainly in terms of our understanding of the impact that a communication disability can have on somebody's ability to access justice, yes, we're learning a great deal.
And stereotypes. We've heard about the stereotypes facing people who use a mobility device. We've heard about stereotypes facing people with a learning disability. What kind of stereotypes are out there regarding people with a communication disability?
Very similar to the ones we've already heard about. I think probably the biggest, and again, I'm repeating what has already been said, the biggest stereotypes would be around credibility, believability, and honesty. So somebody who's communicating unclearly, perhaps to the listener, that comes across as, well, maybe they're not really telling the truth. They haven't said this in a way that's easy for me to understand. Or somebody whose answer to a question doesn't appear to respond to what was asked, that may seem as though they're making this up, when in fact they haven't actually understood what the content of the question really was.
And the relationship between a communication disability and intellectual disability.
There are overlaps, but they are not completely, they're intersections, but they're not completely overlapping. So you can be somebody with a communication disability. You may also have physical disabilities. For example, if you're somebody who has cerebral palsy or somebody with multiple sclerosis, you may also have a number of learning disabilities. You may also have an intellectual disability, or you may not.
But the fact that they can't communicate effectively doesn't mean they don't have an active mind.
Absolutely not. And this is one of the real challenges when we start to think about how that person can participate in a justice system. Obviously, it's critical that they be participating as the author of their own story in an autonomous way. If we make the mistake of thinking they can't do that, we are really denying that individual access to justice.
Now, one other group that we haven't mentioned, but we should just add as we get to understand the population, we're talking about people on the autism spectrum.
Some of those people have a communication disability, not all, and certainly not all people with a communication disability are situated on the autism spectrum.
And somebody on the autism spectrum has a communication disability, how might that manifest itself?
It can manifest itself, I think, really in similar ways to what we've already talked about. So the person may not have the vocabulary, may not have the physical ability to communicate in the same way that, say, you and I are having this conversation, or they may have difficulty processing information that is coming at them.
All right. Now, who diagnoses a communication disability?
There's a couple of ways that a communication disability could be diagnosed. Commonly, it would be by a speech-language pathologist. So let's say this is a young child. The parents have noticed that there are some speech and language difficulties. They talk to their family doctor. The family doctor refers them to a speech-language pathologist, and that individual is able to take the child through a series of tests and determine, yes, this is a communication disability, here are the supports that are needed, not only here are the deficits, but here are the strengths. But it could also come about as part of a larger diagnosis. Let's say I have a stroke, and as a result of that stroke, I'm left with, among other things, aphasia. So my communication disability may be diagnosed as part of a bigger health care exploration of what this stroke has created for me.
All right, and a lawyer, let's just situate us in the spectrum we've just heard about the two other panels we've done. Some of the physical disability, they come into your office with a walker or a cane or wheelchair. We know they got a physical disability if they are still walking but with no device to assist them. If they tell us they can't walk long distances or whatever, we find out. Someone comes in with a learning disability, other end of the spectrum, it's more of an invisible disability. We may not know about it and may not clue into it until they either tell us or we ask them proactively, hey, the courtroom's a very active communication place. Do you have any limitations in the kind of verbal or print communication that you're going to have to do in a courtroom? Don't word it the way I just did, by the way. That was really badly expressed. But in any event, where are we in the spectrum of communication disabilities? Are folks watching this webinar, somebody walks into their office, are they going to know pretty fast they got a communication disability?
Maybe, maybe not. I think, as can be said with respect to all of the disabilities we're talking about this afternoon, because we're functioning in a society that is still highly biased against people with disabilities, people with many, many kinds of disabilities do everything they can to hide that. So if I have a speech and language disability such that I'm having trouble understanding when you're communicating with me, I may well sit there. So you're my lawyer. I've come in to talk to you about preparing a will, or maybe I'm going to be a witness in a case. I don't want to admit that to you. And so as you're talking to me, I'm nodding, I'm giving you all the cues that you think I'm following right along. And then finally you ask me a question and my answer is so inappropriate that you realize either I haven't been listening to you or I haven't understood what you're saying.
And that, for those who watched our one of our earlier webinars, can also be confused with an intellectual disability. And it's one of the challenges we face is trying to sort out, is it a problem with communication or an intellectual problem with understanding?
And that's where you want to bring in somebody like a speech-language pathologist who could help you sort that out.
Because that's what they do.
That's what they do. We're not expecting lawyers or paralegals to be able to meet with a witness and do this determination on their own. What we would like them to know is who they can call on to assist them with that.
All right, now let's turn to the court process, which is what brings us here today. And it's not rocket science, just rocket science for me to offer the penetrating insight that it's a heavy communication place.
It's all about communication.
And we've got someone with a communication disability, so obviously they're going to face problems. Other than in the courtroom itself, what about just getting to the courtroom?
Well, I'm going to go back maybe even a step farther than you're intending by your question to say that one of the real challenges for people with communication disabilities, if we think just for a moment in the criminal court context, and if we think even more specifically about victims of crime, is they just don't appear. They don't ever call the police to say that they have been the victim of a crime because they're so apprehensive about their ability to communicate effectively, or maybe they've called the police, but they haven't received a response that would encourage them to go any further. So before we start thinking about getting them to court and what's going to happen at court, really we need to look at that very first step, particularly in the criminal context, of how do we ensure an environment that enables people to come forward. But lots of people with communication disabilities don't understand that they have a legal right to access to justice in the same way that everybody else in the community has. And so they don't bring their concerns forward, they witness a crime, they don't think anybody is going to be interested in their opinion, so they don't take steps to share what they know with somebody else. It isn't just in criminal court, the same kind of issues can come up in family court and other civil court proceedings, of course.
So unlike people with a learning disability who we heard are overrepresented in the court system, we're talking about people with communication disabilities who may be very underrepresented
Certainly when it comes to, in criminal court, people who are victims of a crime. People who have been accused, if they are the person who has a communication disability, they're going to have many of the same challenges that people with learning disabilities have. Demeanor, ability to tell their story in a way that's believable so that they seem credible, so they may well, in fact, find themselves overrepresented in being found guilty.
All right. So all of this relates to the start of just invoking the court process. Once you're there, finding the courtroom.
Finding the courtroom is not as challenging for somebody with a communication disability as it may be for somebody who has a visual impairment, for instance. Many people with communication disabilities can read without particular difficulties. However, they are going to be coming into court, as the previous speakers said about individuals with learning disabilities, with a very high level of anxiety. And that's going to interfere with their ability to comprehend anything that's going on around them.
Yeah, you're going to a courtroom where it's all about communication, and your limitation is communication. That's got to produce some added stress. But if you've got a stroke or cerebral palsy and your speech isn't clear, you come in, it's a noisy rotunda or whatever, or anteroom, and you ask for directions.
It's going to be difficult. The person you're asking may not understand what you're asking. Unfortunately, they may be dismissive of you simply because you're a person with a disability. Then you have to process the information you've received. And if you're somebody who has a communication disability as one of an array of disabilities, then you may also have mobility issues and other issues in terms of getting from that anteroom or the lobby into the courtroom. And think about it for a minute. All of us who work in courts, we talk in our own language. So we're now placing somebody who has a communication disability when it comes to their daily life in an environment where everybody's talking yet a different language.
All right, let's go from the problem to the solution. Let's go, who can assist? You've got a person with a communication disability. We know if you're a deaf person, you can get sign language or captioning. You speak a different language, we get an interpreter. Who do we call for assisting the effective communication of somebody with a communication disability?
CDAC has just started to develop a roster of people who are trained speech-language pathologists who have taken additional training to work as what we're calling communication intermediaries.
Okay, I'm going to stop and have you tell us again. CDAC is?
Communication Disabilities Access Canada.
This is an organization, a fabulous and groundbreaking organization, which exists to try to come up with solutions for people with communication disabilities involved in the court process, correct?
That is part of what CDAC does. It isn't just focused on justice issues, but it's been an increasingly important part of our work because we see how vulnerable this population is in that context.
So they've invented this new service called Communication
Intermediaries.
Who is that and what are they? You said it's a speech and language pathologist plus.
That's right. So in some ways, I guess an easy way to describe what a communication intermediary does is to say it's the equivalent, if you will, of somebody who is interpreting language or somebody who's providing American Sign Language interpretation. These are speech-language pathologists who have taken additional training. It's training that we offer at CDAC to help them understand the issues that are going to come up in a court setting, the kind of language that might be used there, how they can work with the lawyers who are involved in a case. In fact, our communication intermediaries can work with a client right from the time in the criminal context, let's say, that they're involved with the police, giving that initial statement to the police, whether that's as a victim or as an accused, right through to the end of the trial process.
Including in the law office?
Absolutely, including in a law office.
Okay, and so what do they do? I mean, sign language interpreters do sign language. What language do these folks use?
The first thing that a communication intermediary does is a full assessment to understand what the needs of the client are. Because they are speech-language pathologists, of course, they're familiar with a wide variety of communication disabilities. They'll complete the assessment. They work not for the individual with a communication disability, but for the end user. So, for instance, at the first stage, if it's a criminal case, they're working for the police. So they're assessing what this individual's needs are to communicate effectively with the police. Later on, it might be their needs in terms of effective communication with the Crown or with a defense lawyer.
Every defense lawyer watching us just got their back up and say, whoa, they're working for the police?
They're being paid by the police.
Gotcha.
And their goal at that first step is to create an assessment report that they can hand to police officer, Crown attorney, defense lawyer, victim witness worker, maybe the court accessibility coordinator, to say, here's my assessment of this individual's disability. Here's what I believe this person needs in order to have access to justice in this court case. So that might well be, I'm proposing that I will come in as the communication intermediary. I will interpret for the court what this client is saying. So I will take their language and turn it into language that the rest of you can understand.
So we got somebody with a stroke. We don't understand a word they say. This person does?
That's right. Because they're trained, they'll work with that person, they'll understand how they communicate, they'll learn their cues, they'll learn the body language cues. And very often, as we talked about earlier, this person is using a device, which the speech-language pathologist, now communication intermediary, has become familiar with and knows how to use.
So they can add access technology to their approach?
Absolutely.
And may that involve, let's say, somebody watching this as a client or a witness who's got a communication disability, might that involve introducing them to a new adaptive technology that the client's never used before?
It might, but it would be our hope that the communication intermediary is working with the individual who's using either technology or techniques that they're already familiar with. Let me just go back half a step here for a second, David, because often, because it may not be immediately apparent to the lawyer or the paralegal that this individual has a communication disability, if there are some issues, the communication just isn't working properly, the first step might be to ask that individual, is there somebody who generally helps you with communication? It might be a family member, it might be a friend, it might be somebody, an attendant care provider, and so on. And that person might be then the avenue through to connecting with communication intermediary services.
Okay, and anybody who's got a friend who's had a stroke or got cerebral palsy will know if you've been around an individual, you get used to their speech, even though others may, on first meeting that person, may not be able to understand them at all.
One of the real challenges, actually two real challenges, are one, to make sure that that individual, if it's a family member or a friend, it, in fact, has the best interests of the individual in mind, that they're not part of whatever bad thing has happened to that person. And the other issue for us is to ensure that the assistance of the communication intermediary maintains the autonomy and the authorship of the individual's story.
Right. This is an issue that when in our second webinar, we had a panel on hearing loss, where a professional sign language interpreter is independent of everybody. If it's a family member who's doing the sign language, there could be other issues about their
that's right.
objectivity.
And very similar issues here. So if I was a communication intermediary for you, if you had a communication disability, it would never be appropriate for me, for instance, to say, well, I think what David's trying to tell you is this, right? I'm not your advocate. I am there to interpret from the way you're communicating into a way that the court can understand.
Okay, now you've said this is all relatively new, and CDAC is blazing some important and very valuable but very unblazed trails. Are there standards for qualifying as a communication intermediary? Is there certification?
Not yet. So these intermediaries have received the training that CDAC provides. We've created a roster of people who have taken that course, but we can't certify as to their capabilities. We simply don't have the resources to do it. What I can tell you is that on that roster, there are 194 speech-language pathologists across the country who've taken our course and who are available to provide this assistance. 58 of those are in Ontario. So if any of the people listening to this webinar are the end user that I described earlier, they can access that roster through our website, connect with a speech-language pathologist who has become a communication intermediary, and discuss with them what role they might play, the appropriateness of that, and so on.
And if somebody wants to use one of these individuals in court, what do we do to satisfy the court that they're qualified if they don't have a certification process?
We have encouraged the communication intermediaries that we have trained to come to court prepared to provide a curriculum vitae, prepared to entertain some questions either from opposing counsel or the judge or both, and also to be willing to swear or affirm to an oath that they understand what they're doing, they understand the particular needs of the court system in a similar way to the way that sign language interpreters and language interpreters take an oath in terms of their participation in the court process.
Okay. The last area I want to just ask you about briefly is, what do judges know about this stuff? A lot? Not much?
No, not very much. There's great judges, we all know that, who can spot a problem in the courtroom and they will work on their own to figure out a way to address it. I think typically right now, until the communication intermediary program becomes better known, what a judge in that situation might do is ask the person, is there somebody who can help you communicate? That's not a bad thing, but it may not be as good as having a professional and trained communication intermediary.
So one of the roles that counsel can play is, and I've been pushing this theme throughout the afternoon, is educating the judge. That might involve calling the communication intermediary to explain, not just to qualify themselves, but to explain what the communication disorder is and why it's needed to assist and how it can assist and why it can be reliable.
That's right, although we actually think it's preferable if the lawyer calls another speech-language pathologist to speak to that issue, so there's no question about a conflict between the intermediary. There's no possibility that they are then perceived as crossing the line into advocating on behalf of the client. But getting that evidence in front of the judge is very important. One
way or the other, and possibly, if it's going to involve an assessment by a jury, possibly getting it in front of the jury as well.
Absolutely right.
All right, well, thank you very much. What I'd like to do is we're going to now go into our concluding few minutes. I'm going to invite the camera can pull back and show that happily with us still and hopefully conscious is Stacy and Mitchell on my right side, and on my left side joining us again will be our first panel. And for those of you in our audience, you can send in questions using that Q&A link. I'm going to just talk for a minute while Jill is going to madly look at the iPad, which hopefully will show either the baseball scores for the afternoon or the questions that we've received and select ones that we can answer. But let me segue while Jill is madly looking at you do have the iPad, I trust? And I just want to offer a couple of observations, if I can. Judges in our country have been learning more about this than ever before. That's not to say there isn't more for them to learn. There's lots for them to learn. I've had the privilege for at least 15, if not more years, of speaking at each of the courses offered for new federally appointed judges, and presentations have been made at other courts around the country on accommodating the needs of people with disabilities. The National Judicial Institute also makes available to at least all federally appointed judges, I'm not sure if it goes further than that, a bench book, which is a handy guide to the accommodation needs of people based on different kinds of disabilities. And I will tell you that from my training of judges over the years on this, I have found they are incredibly eager to help and to do the right thing. The thing that's significant for counsel or paralegals to know is that when they're up there on the bench, they almost never know that someone has a disability. In fact, I'm going to turn to Harley. Have you had judges ever ask you to stand up?
Oh yeah, more than once. I remember as a law student and also as a practicing barrister being admonished by the judge. It is customary to stand, Mr. Knott, when addressing the court. And I had some answers to that, but I couldn't be too much of a smart ass because it is, after all, a court.
Yeah, no, I once spoke with a judge who accidentally said to counsel, it's customary to rise in our court when you speak, and the counsel said, I would, but I'm in a wheelchair, and the judge quietly confided in me that they sort of wanted to shrink under the bench at that point. Similarly, for me...
I won both cases that I can think of where that happened.
the Crown never wins.
Right.
Or loses. When I go to a courtroom, I got a white cane, but by the time we sit down, I put that cane on the floor when the judges come in and say, all rise. I'm just another counsel in the courtroom. If they know me, they may remember that I can't see, and if they don't know me, they don't. So it's really important for counsel to realize that, and paralegals to realize when in court, alerting the court access coordinator as early as you can is really hugely important. If you've got to raise it, if you're going to need to identify an accessibility need in court, raising it in the courtroom for the judge in a respectful way. Our panel that we did in an earlier webinar talked about really creative and clever ways to raise mental health issues and our intellectual disability issues. It might just be a matter of explaining to the court, in this case, that an individual has needs supports for their communication, and we will bring to the court's attention how that's done. Or we have witnesses for whom reading and writing printed material requires them to have certain assistance, or if they find that reading the printed word is easier for them than hearing the spoken word, and for which we've asked for an accommodation to be set up. We're not putting fancy labels on it, just telling them what they need. In my experience, judges are going to be quite receptive to that. But not if they're hit with it at the last minute and it's going to require some major disruption of the trial, ergo raise it early. Jill, what do we got?
Well, we have a few questions. A couple of them are about learning disabilities, so I'll combine those. And one of them is about the expertise or qualifications a psychologist might need to have to identify what some of the needs are.
Okay, so let me turn to...
and then the second question is, and who pays for that? Is that the individual, or is it the healthcare system?
Okay, so maybe Stacy and Mitchell, can you help us out? Any psychologist will do, or do some have more specialty in this? And from your experience, who pays?
I think you want a psychologist who is in good standing with the College of Ontario Psychologists. For one thing, you want to know that they're certified with that college. As far as the, we're talking about payment for, psychological assessment, right? I think that is responsibility of the individual. So, the cost for such an assessment can go somewhere between $2,500, $3,000. But I think there are organizations out there that will do that on a sliding scale. I think the universities have psychological services that can do that, as well as it was the Jewish Vocational Services that does psychological assessments on a sliding scale.
Stacy?
Yeah, I think Mitchell really tapped in. There are also psychologists that might have, all psychologists, like Mitchell said, within the Ontario College of Psychologists, it would be able to do the assessment, but there are certain psychologists that really focus in on doing psychoeducational assessments. I know that our association, the Learning Disabilities Association, we have a list of those on our website for individuals to kind of find certain psychologists that specifically do psychoeducational assessments without having to go through a broader search process for them.
And obviously, if it's psychoeducational assessments, typically are done for kids, not only, but often are done for kids, so you'd be looking at child psychologists. Of course, the best bet is to approach the psychologist and say, do you do these kinds of assessments, and have you done them before? There are, if you're dealing with a client who's in school, some schools have some psychology services, but typically backlog, but they might have already done a psychoeducational assessment of an individual, if it's a student in school, for purposes of dealing with their educational placement. So there may be an assessment already done. The family may or may not remember whether it was done, or the individual may not know because it might have been done some time ago. But it's also worth talking to a healthcare provider that you deal with to see if they could refer you to services, whether they're funded or not funded.
Right. To speak to that issue, David, about early psychological assessments, a lot of times in the educational system, the psychological assessment is done to ascertain a learning disability as early as, say, grade 3, around the time that a child is 8 years old. They used to do reassessments at the intermediate level prior to a student, entering secondary school, but they've cut out that practice because of, I guess, financial considerations. So a student can roll into, a secondary school and into post-secondary education with an assessment that was done back when they were 8 years old. So it's not necessarily the case where a student coming out of high school would have an assessment done. That would really fall to the responsibility of the family, and we often encourage families to consider that, because the universities require an assessment within 3 years of entry to post-secondary to justify the accommodations that they provide.
Okay, Jill, what else we got?
David, if I could break in for a second.
Sure.
Just the discussion of money reminded me of a thought I had earlier when Jill was speaking about lawyers and their clients contacting the accessibility coordinator in advance and coming up for a reconnaissance to a courthouse in advance of a proceeding. Money is always top of mind for anybody in private practice, and the question always is, who pays for that? I mean, if the lawyer accompanies the client, is that something that it's reasonable for the lawyer to bill the client for? Does the Attorney General kick in, pay the lawyer's fee, or is that just something the lawyer absorbs? Because there are incentives and disincentives to do that kind of advanced reconnaissance depending on what the answer is.
Yeah, a lot of times, when in school, when we have to, suggest to a family that they go out and obtain a private assessment, that we suggest that they get a referral from a medical doctor. In this way, if they have an insurance plan, they could recoup some of the money that they pay for that assessment.
Yeah, some workplace private insurance programs will provide some coverage. Jill, what else we got?
Just one other question. It's kind of the same question, two different ones, but so what types of accommodations are available for court for people with learning disabilities?
Maybe, Jill, is there anything beyond what we've heard from the panel on accommodations in the courtroom for people with learning disabilities? I mean, we've already covered the issue of possible breaks, about explaining to the court, the judge and jury about their needs, pacing of questions, using adaptive technology. Do you folks get requests in relation to learning disabilities?
Yes, we do, and certainly the ones that you've just mentioned are the things that are explored. Just to add to that, though, sure. We sometimes will get requests, send me all the documents a few days in advance. I need those in advance. Don't present me with something like the night before, because I'm going to need some time to go through those documents with my assistive software, and it might take me longer to process that information. So we have those kinds of arrangements that are made with the accessibility coordinator to the extent that they have the documents in advance. Some of this would also need to be discussed with the presiding judge, because timelines might also be affected. And so in terms of response times, if you normally have 30 days to respond, somebody with a learning disability may need a little bit longer due to their disability-related needs. So those sorts of things would need to be discussed with the judge, and the presiding judge would have to decide on what the process would be. The other in-court support that we've used is, so if somebody has difficulty processing information orally or verbally, and they sometimes may need the written documentation to supplement their understanding, hearing at the same time. We've used real-time captionists. So real-time captioning is the presentation of, essentially it's the transcript being presented as
In real time.
In real time. And so that can be helpful, along with then having some time to pause and go back and review the written documentation, just to make sure that people are processing and understanding the information.
And just as yet another shameless plug, if you watch our second in the webinar series, we had a panel which included a real-time captionist as one of the presenters, explaining how that whole process works in the context of hearing loss. Okay. And if I could build just on what Jill was saying about those watching us must wonder, wait, you got to provide a witness with documents in advance of a trial? That sort of seems odd. But as a blind individual practicing law, and we require that in any case. Any lawyer who walks in and hands something to me in a courtroom that they haven't disclosed to, in advance knows they're going to face a request for an adjournment while I read it. And if they were to do that in a case where a witness needs to read it, the same is going to happen. And in my years of practice, lawyers generally don't do that to me because they know what the consequence of doing it will be. In this case, you might wonder what's involved in making the document available in a format that somebody with a learning disability like dyslexia can read. I earlier said it's software similar to what I use. What that means is if it can be scanned, if it's already in a format like Word, or it can be scanned and optical character recognition can be done that converts it to Word, then typically they can be emailed to the individual and they can load it on their computer. And you could even have a laptop right there in the courtroom. The person might bring their own even, and they could pull up that document if they're going to be asked questions about it and read it using an earphone right there with the screen reader just reading it out loud. This stuff is easy to do. It's not expensive. Doesn't take a lot of time. And frankly, I would think every law office is probably now equipped to do scanning and optical character recognition, not for people with learning disability or vision loss, but for other uses. It just can be applied to us.
Yeah, and I just wanted to add to that. I mean, if you consider, for example, if the other counselor, the other party, for example, had somebody with a disability, I mean, ideally, from our perspective within the ministry, we would like for these things to just be done between two parties, where we don't have to be the intermediary of send me the document, and then I'll go send it to the other client. So the extent that that can be dealt with between the two parties, that is better and more timely, but we have got involved when needed to I guess, be the intermediary.
All right. If those are the questions, I'd like to just take a few minutes to wrap up. I want to begin the wrap up by saying that what you folks don't get to see when we do this presentation is the fabulous support that the Law Society provides us. And they are all an amazing team who make our jobs a lot easier in presenting these, and we're indebted to all of them, from the technical folks to the organizational folks to the secretarial folks to the folks that make sure all our speakers are here and that you've got all the materials on screen. So a huge thank you to all of them. If I controlled production, we'd roll credits right now, but I don't. Let me just give you some concluding ideas. Take the propositions you've just heard about and think about it beyond what we talked about. You've heard about people with communication disabilities or learning disabilities and the effect that that can have on their ability to receive and convey information verbally in a way that will be understandable by someone in court. Now, let me graft onto that something that anyone who practices law in a courtroom knows, sees all the time, which is cross-examining on a prior statement. Whether it's a witness being questioned about a statement they gave to police, or a discovery transcript, or an affidavit or something else. If it is somebody with a learning disability or a communication disability who did not have the appropriate supports in place, who may not have self-identified at the time as having needing any supports, they might be cross-examined on a statement. Well, you may have said that today at trial, but when you were talking to police, you said something very different, and which is a way to impeach their credibility. But if you know or learn through your preparation for the case that that person, for example, had a learning disability, they may not have either effectively understood the question asked or processed and been able to verbally communicate, or they may have done all of that, but when they read and signed the statement, they may have had a limitation in their ability to process the information in it. And that statement and a cross-examination on them, which on its face might be a damning form of cross-examination, you'd said something very different at trial here than you said back when you were talking to police. Wasn't your memory better than then than it is now, and the usual stuff we do to witnesses may all of a sudden take on a very different hue if we educate ourselves on this, if we learn about it, and if we're in a position to put that information in a proper way before the trier of fact. Let me encourage you at watching this to do several things. No, I won't plug watching the other 3 episodes of this series I just did. But what I will say is there are several ways beyond the action tips we've given you today that you can make a difference. If you encounter barriers in the court process, let the ministry know through its feedback process, and let those of us know who are on the Ontario Courts Accessibility Committee. You can email me or contact me, and I'm on that committee, or we'll find other ways to raise it. It's often an individual's instance or account of something that happened that brings our attention to something that was overlooked. So you're bringing those stories forward, good and bad, success stories or failures, that really help us. If, as I said at the end of the first panel, you've got a court in your community which has significant accessibility problems and you don't see things moving quickly enough on it, feel free, which has significant accessibility problems and you don't see things moving quickly enough on it, feel free to use our democratic process to bring it to the attention of the ministry, the Attorney General, your local MPP, and urge them for change. Remember, I adverted to this at the beginning, I'm going to advert to it at the end, that your law firm has obligations, or your law office has obligations on the Accessibility for Ontarians with Disabilities Act. There are customer service standards, there is a standard governing employment and workplace accessibility, there is a standard requiring the accessibility of information and communications, there are amendments to the building code on physical accessibility, and I imagine that your law firm doesn't have a beach or a recreation trail in it, so you might think the public spaces accessibility standard has nothing to do with you, but it does have requirement for accessible counters in a public service area. So if you have a counter which you invite people to come to, there are measures that can affect you. You should look at those. One of the really important ones that I'm going to gamble a lot of you don't know about is website accessibility. Your law firm has a website, and many, if not most, do. There are steps you can take to make sure your website is accessible to people using adaptive technology, whether it's due to blindness, learning disability, physical disabilities, hearing loss, color blindness, whatever. There are international standards. It's good for your firm's business to make sure your website's accessible, since after all, a website is there to help get more attention to your services. If you're cutting out 10, 15, 20% of the public from reading your website, not so good for your bottom line. It's worthwhile also to know that posting information on your website just in PDF is an accessibility barrier to a lot of us who use adaptive technology. You should make an alternative format available that is in a format like Word or HTML that more of us can read. When your IT people tell you to worry because PDFs can't be copied, tell them they're wrong, and that's nonsense. You can copy PDFs, and as long as you've got the original document, who cares if people mess with them? You've got the original to prove what it said. And so there are all these kind of steps, and underlying all of this, when you look at the accessibility standards enacted under the Disabilities Act that relate to you as an employer and you as a service provider, it's important to understand that they have timelines that are sometimes a bit luxurious and long. But your obligations are ultimately under the Human Rights Code to provide equality in services, facilities, and employment. And to the extent that you have a duty to accommodate under that legislation, if it requires prompter action than the timelines under the Disabilities Act, the more exacting accessibility standard or requirements prevail. So thank you very much for tuning in. We welcome your feedback on this program, and let us know what future topics you would like us to include. Thank you very much to our speakers, and wishing everyone a good day.
Thank you, David.